back to Counting. Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host. This is our weekly YouTube live stream being broadcast live Thursday, April 5th, 2018 at 9 p.m. Eastern Time. And this live stream will also be posted as an episode of the Counting to Five audio podcast. If you're watching live, please feel free to ask questions in the YouTube live chat at any time, and I'll try to monitor it and periodically answer any questions as they arise. In these weekly live streams, we keep up to date with the latest Supreme Court news, and here's what I plan to cover today. In the last week, the court granted one new case, a case called Stoeckling v. United States, which will be heard next term. That's a criminal law case about the Armed Career Criminal Act. I'll talk about that a little later. The court also issued a few opinions. There was only one opinion in an argued case. It's a case called Encino Motorcars, and that's a case about an exemption from federal overtime requirements for certain car dealership employees, and I'll talk about that a little later. The court also issued one summary per curiam opinion. That's an unsigned opinion in a case that was decided without oral argument or full briefing. And also, Justice Sotomayor issued an opinion dissenting from the court's denial of review in one case. And I'll be discussing each of those. But first, before I get to that, I want to give a quick update about another case on the court's docket that we've talked about before, and also take a look at a very unusual order from the court this week in another case. So I'll start with those. First, the update is in the case United States v. Microsoft. And if you've listened to previous of these live streams, this case has come up a number of times. This is a case about the government's ability to obtain emails that are stored on a server outside the United States using a warrant under the Stored Communications Act. So this is when law enforcement is trying to obtain emails for some investigation. If those emails are stored outside the country, can they obtain them? And this was argued earlier this term. This case was already argued and is just pending, awaiting a decision of the court. But I've discussed in the last few weeks, there's been some developments that directly relate to this case. And just as a quick recap, what happened was 2 weeks ago, on Friday, March 23rd, Congress enacted the omnibus spending bill. There was the large spending bill, the 2,000-plus page bill that included numerous provisions. One of the many things included in that bill was something known as the Cloud Act, which is an amendment to the Stored Communications Act that explicitly allows the government access to emails stored outside of the country. So after the passage of that act on Friday, March 23rd, the government sent a letter to the court advising the court of this new legislation and saying that it intended to file a supplemental filing in the Microsoft case, basically to discuss how this new legislation should affect that case. So the new developments that have occurred is this past Friday, on March 30th, the government did file a brief in the Microsoft case arguing that the case is now moot. So the government argues that the Cloud Act, the newly passed Cloud Act, does apply to the original warrant that they had obtained under the Stored Communications Act. So it would retroactively apply and now allow access to overseas data under that. But apparently Microsoft had disagreed, this is behind the scenes, with that argument that it applied retroactively. So what the government had done is they went ahead and applied for a new warrant on March 30th, received that warrant from the court, which basically superseded the original warrant. And this new warrant is clearly governed by the Cloud Act, which has specific provisions for this overseas data. So that would make the original case, which was based on the old version of the Stored Communications Act before this amendment, that would make that moot. It's totally irrelevant now that warrant is no longer at issue in the case. So Tuesday, just 2 days ago, April 3rd, Microsoft responded and agreed with the government that the case is moot due to this the new warrant under the Cloud Act. And then yesterday, the court set this motion to dismiss this case as moot, set that for their April 20th private conference. So in a few weeks, this case will almost certainly be gone. This is a case that'll be disappearing off the court's docket. It hasn't happened officially yet, but I think we can expect the orders list that comes out after the court's April 20th conference will likely show that this case is gone. The other case, this is a very unusual situation. It's a case called Deutsche Bank Trust Company Americas v. Robert R. McCormick Foundation. Now, this is a case that's spun out of a bankruptcy of the Tribune Company, which is a major media company that published the Chicago Tribune, among many other newspaper and broadcast properties. There's a very unusual order. It's actually not an order at all because it doesn't have any legal effect. It doesn't actually tell anyone to do anything. But here's what it is. It was phrased as a statement respecting the petition for certiorari, and it was by Justices Kennedy and Thomas, only those two justices, and I'll come back to that in a minute. And here I'm just going to read the full the language of this statement, and then I'll kind of explain what's going on here. Here's what it says. It says, the parties are advised that consideration of the petition for certiorari will be deferred for an additional period of time. This will allow the Court of Appeals or the District Court to consider whether to recall the mandate, entertain a Federal Rule of Civil Procedure 60B motion to vacate the earlier judgment, or provide any other available relief in light of this Court's decision in Merit Management Group v. FTI Consulting. The petition for certiorari in this case was pending when the Court decided merit management. The Court of Appeals or the District Court could decide whether relief from judgment is appropriate, given the possibility that there might not be a quorum in this court. So what is going on here? I'm going to break this down a little. The court is basically saying, we're not going to do anything on this case for a while, but lower courts, maybe you want to step in and do something in the meantime, hint, hint. What's going on here? So what this is about, it's about a process the court has, it's known for short as a GVR, which stands for grant, vacate, and remand. And what it is the court will sometimes when the court has multiple petitions, so there's petitions of certiorari, that's the formal petitions to the court asking the court to take and hear a case. Sometimes the court has multiple petitions on the same legal issue or on some overlapping legal issues. And sometimes the court will only grant one or maybe one or two of those petitions, and there's others that are just pending before the court on that same issue. Or sometimes the court has already granted a petition on an issue, and then after that point, while it's pending, additional petitions are filed in other cases on that same issue. And what the court does with these kind of duplicate cases or cases raising the same issue is normally the court will just hold these cases pending the resolution of the case that they granted. And holding it just means they take no action on the case. It just kind of sits in limbo, waiting for the case they've granted to be resolved. And then what this allows the court to do is, if the case that they granted, something happens to it, it ends up being dismissed for technical or procedural reasons. Maybe the parties settle the case, or maybe there's some sort of issue that one of the parties to the case didn't really have standing to bring it or something like that, and they have to get rid of the case for a technical reason, then maybe the court can go and grant one of the other ones they've been holding and still resolve that issue. But more typically what happens is the granted case gets decided. The court hears the argument on it, the court issues its opinion, its decision in that case, and resolves the granted case. And then what the court will do is, shortly after deciding that case, the cases that it had held are GVR'd, granted, vacated, and remanded. What the court does is it grants the case for the sole purpose of immediately vacating the lower court opinion, that is legally nullifying that opinion, just kind of wiping out the lower court's decision in it, and then remanding it, that is sending it back to the lower court to reconsider in light of the case that the court just decided. So they basically decide one case on a particular issue, take all the other cases on that issue, and send them back down to the lower court and just say, take another look at this in light of what we just decided. And then the lower court has an opportunity to see if the Supreme Court's decision, causes them to have to change what they did in the case to decide it a different way or something like that. So that's the typical process, this GVR, and it happens fairly regularly. So the case that's at issue here, the Supreme Court case, there's a case called Merit Management Group v. FTI Consulting. And the court decided this case, issued its decision and its opinions in this case on February 27th. And this was a case, it was a bankruptcy case. It was about a bankruptcy court's power to unwind certain financial transactions that happened before a bankruptcy was filed. So sometimes certain financial transactions are engaged in by the party that then declares bankruptcy. A court can actually step in and undo those transactions after the fact. And the case that we're talking about here, this Deutsche Bank case, relating to the Tribune Company's bankruptcy, it raised, among other things, it raised the same question of bankruptcy law as the merit management case. This case about whether certain transactions can be unwound after the fact. So normally, where GVRs happen, I'm just going to give some examples from very recent examples from earlier in this term in other cases. On March 21st, the court decided a criminal case called Marinello v. United States. It was about obstruction of the administration of the tax code. So that was decided on March 21st. In the following Monday's order list, the court granted and vacated a case called Westbrooks v. United States, remanded it to the lower court for further consideration in light of Marinello. So that's a classic GVR right after the decision is issued. Another example, February 27th, the court decided a case about immigration detention called Jennings v. Rodriguez. In the immediately following Monday's orders list, the court granted and vacated a case called Shanahan v. Laura and remanded it to the lower court for further consideration in light of Jennings v. Rodriguez. So that's the common pattern you see is they decide one case, and then any cases they've been holding on the same issue, they send them back down. So why couldn't the court GVR this Deutsche Bank case in light of the merit management group thing? So when they decided merit management, why didn't they just GVR this case, send it back down for reconsideration? And the issue is the court's quorum requirements. And it appears the court does not have a quorum to decide this case. Now, what does this mean? There's a statute, federal statute. It's 28 USC 1. Right? That's the code citation for the statute. It reads, "The Supreme Court of the United States shall consist of a Chief Justice of the United States and 8 associate justices, any 6 of whom shall constitute a quorum." So they need 6 justices in order to decide a case. Now, normally it takes 5 justice majority. It takes a majority of the justices that are hearing a particular case to decide a case. But if they have less than 6 hearing a case, then they don't have a quorum and they can't even hear the case. Now, in this case, fully 7 of the 9 justices are conflicted out of this case because they hold shares in mutual funds managed by parties to the case. Now, the cert petition, the petition includes literally about 150 pages just listing. All right. I just had technical difficulties. My feed cut out, but it appears we're back. So I hope you're still sticking with me. But when it cut out, I was saying that the petition in this case includes literally 150 pages listing the parties to the case, and includes hundreds of financial institutions. And the situation in this case is that many of these parties listed are shareholders of the Tribune Company who were affected by the way the company's reorganization and bankruptcy played out. And so it includes these numerous financial institutions that were shareholders of the company. And as I said, hundreds of financial institutions. The real surprise is there's any justices left who aren't recused. But as I said, 7 of the 9 justices are conflicted and would presumably have to recuse themselves from hearing this case, and leaving only Justices Kennedy and Thomas left to decide the case. So what happens when the court doesn't have a quorum? There's another federal statute. This one is 28 USC 2109, and it reads in part, it says, if a majority of the qualified justices means those that are not recused. This is a procedure when there is not a quorum. It says, if the majority of the qualified justices shall be of the opinion that the case cannot be heard and determined at the next ensuing term, the court shall enter its order affirming the judgment of the court from which the case was brought for review with the same effect as upon affirmance by an equally divided court. Now, what that last part means, the same when there's an equally divided court. So, for example, if there's one justice recused and the court splits 4-4, what happens is the lower court opinion is just affirmed, so it stands. Whatever the lower court decided stays in this particular case, but it has no precedential value for future cases. It doesn't count as a Supreme Court decision on that case. So it's saying the same thing happens here. If you have no quorum, then the remaining justices can can decide whether they think this will be able to be heard at next term. So if this is a temporary lack of quorum that may be resolved in the near future, they don't need to do that. But otherwise, they just affirm the lower court decision, and that's that for the case. So normally in this case, without this whole quorum issue, the court would just GVR the case, send it back down so the lower court could reconsider it in light of the merit management decision. But with only 2 justices left on the case, they can't even do that. They have no quorum, so they can't even grant it for the purpose of vacating and remanding. So what do they do here? They basically are stalling. They say consideration of the petition for certiorari will be deferred for an additional period of time. Very vague, just we're not going to do anything for a while. And they not so subtly hint that the lower courts might want to reconsider their rulings in this case. But the court can't make them do anything. They don't have the power to order the lower court to reconsider or redecide the case. They can't vacate the lower court's judgment in the case. So it'll just be interesting to see whether the lower courts take this hint and decide to reconsider the opinion below. It's just a very, very odd, unusual situation. So moving on to other things, I mentioned that there was one new case granted this year, one cert grant, or this week. They granted one new case. That brings the total grants for next term up to 8 so far. So 8 cases to be heard for the term starting in October 2018. And the next time any more grants will be coming will not be until Monday, April 16th. That's the earliest date where the court could add some additional cases. So we're kind of watching this because the last couple of years the court has had a very light caseload, especially in the fall, in the beginning of its term, and it remains to be seen if that's going to continue, if that's going to happen again this year. So we're interested to see how many more cases they grant before the court leaves for its summer break at the end of June. And right now they've only got 8, but there's still a lot of time to add more, so we'll see. So the one new case they granted is a case called Stoeckling v. United States. And this is a case about the Armed Career Criminal Act. And what this involves is this is a sentencing enhancement for let me back up a second. So the crime that's involved here is the federal felon in possession statute. So it's 18 USC 922G. It's a federal statute that involves people that have been convicted of felonies who are then found to be in possession of firearms or ammunition. And there's a provision, the Armed Career Criminal Act is another provision. This one's 18 USC 924E. Which basically says someone who has been convicted of 922G, so that's the possession, federal felon possession, and they had 3 or more prior convictions for a violent felony or a serious drug offense, so 3 or more prior convictions for violent felony or serious drug offense, then they are subject to a 15-year mandatory minimum for this new felon in possession violation. And the issue here is a violent felony that's defined in the statute as a crime that's punishable by more than a year in prison. And this is from the statute. It says, has as an element the use, attempted use, or threatened use of physical force against the person of another. So element just means that's one of the facts that needs to be proved to convict someone of the particular crime. So one of the facts that you have to prove to convict of the crime is the use or attempted use, or threatened use of physical force. Now, the issue here is most criminal law in the United States is state law. The overwhelming majority of criminal convictions are under state law. However, federal law sometimes imposes consequences for state convictions. This one is a sentencing enhancement, but there are other examples are, for example, under immigration law, whether someone is deportable, it can be removed and deported from the country, may depend on being convicted of certain state crimes. Now, here, the federal sentence enhancement, this Armed Career Criminal Act provision with 3 or more prior convictions, it depends on state law convictions. But the issue is criminal laws, they vary enormously from state to state. There's a huge variation in exactly how different crimes are named and how they're defined, and where the line is drawn, for example, between misdemeanors and felonies, or where the line is drawn between different degrees of a particular offense. And so it's impossible for federal law to specify in detail which state crimes it's meant to apply to. When they want to piggyback a federal provision of federal law on state criminal convictions, they can't point out every single state law, because there's just so much variation in so many different laws, and they're subject to change at any time by all the various state legislatures. So instead, what federal law does is it often attempts to describe an entire category of criminal offense, like the violent felonies here, the description of those here. But this can lead to some difficult line drawing issues in determining if a particular crime fits this definition. So here's the basics of what this case is about. The criminal defendant in this case is named Denard Stoeckling, and he was convicted of being a felon in possession of a firearm. He had 3 prior Florida criminal convictions. There was an unarmed robbery, an armed robbery, and a drug trafficking conviction. Now, the dispute here is over the unarmed robbery conviction. Is that a violent felony under this the Armed Career Criminals Act? So, and the issue is whether something is a violent felony. It doesn't depend on the specific facts of the crime committed by a particular defendant. It doesn't matter what Stoeckling actually did, whether his conduct was particularly violent or not. Instead, what matters is the crime he was convicted of. So this robbery, Florida robbery conviction, how that is defined under state law, whether that is defined under state law in such a way that one of the things that has to be proved is this use or attempted use of physical force. And so the issue here is the Florida robbery. One of the things that's required to convict someone of robbery in Florida is resistance by the victim that is overcome by physical force of the offender. That's a fairly common element in state definitions of robbery. It's a common thing that basically distinguishes robbery from just a theft offense. Elevates something from theft to robbery is that there was some level of force overcoming resistance by the victim. Now, the government argues, well, that's all you need. The fact that you have to apply some sort of physical force to overcome resistance qualifies as the attempted use or threatened use of physical force. The argument on the other side is that Florida law includes even minimal action to override minimal resistance of the victim. And the example that comes up is engaging in a tug of war over a victim's purse. So the fact that a purse strap needs to be pulled out of someone's, the grip of someone's fingers is enough to qualify as applying force to overcome resistance by the victim. But the Supreme Court has previously characterized what force means, physical force, in the Armed Career Criminal Act to mean violent force, which they've described as force capable of causing pain or injury. So the argument here is the Florida law doesn't necessarily require the kind of violent force that the Armed Career Criminals Act requires. Someone could be convicted under Florida law, and again, it doesn't matter what this particular defendant was convicted of, it's just about the crime in general. It's possible to be convicted, the argument is, under this Florida law, even if they hadn't used the type of force that would kind of amount to violent force under the Armed Career Criminal Act. Now, the government, on the other hand, says that this is wrong, basically, that force capable of causing pain or injury includes even minor pain. Even something like a slap in the face would be enough to qualify. And any amount of force that's necessary to overcome someone's resistance could, in theory, be the force that could cause some sort of minor pain or injury, and that's enough to qualify. So that's the issue. And again, the court will take this case up next term, probably October or maybe November, depending on how their calendar shakes out. And so that's it for new cases. And so let's move on to the opinions this week. And there are, as I said, 3 different opinions. One is just a opinion by Justice Sotomayor. I'll talk about that one first, dissenting from the denial of certiorari. So the Supreme Court chose not to take two two cases out of Florida raising a particular issue. Justice Sotomayor issued a dissent from that court's decision. Now, these are cases involving an Eighth Amendment challenge. It's a cruel and unusual punishment challenge to Florida's capital sentencing regime. And this is actually the third time this term that Justice Sotomayor has dissented from denials of petitions on this very same issue. She had one on October 16th. It was a case called Truhill v. Florida. And then on February 26th, a case called Middleton v. Florida. And I discussed this actually on a previous live stream after that February 26th opinion came down. And the issue here, this all comes from a 2016 case called Hurst v. Florida. And that was a decision of the Supreme Court. The majority opinion was written by Justice Sotomayor, which may show why she feels so strongly about this issue. But Florida previously had a capital sentencing scheme where the jury gave a advisory sentence by majority vote, gave an advisory sentence, but then the judge made the final sentencing decision. So this is a decision of life in prison versus a death sentence. And the jury would have given an advisory opinion. The judge would make the final decision. The court found that this was unconstitutional under the Sixth Amendment's right to a jury trial. They said that this determination has to be made by a jury, can't be left to the judge. Now, what happened is here the sentenced convicted capital defendants in each of these cases. It was the two cases are called Guardado v. Jones and Causey v. Florida, and it involves two men who are both sentenced to death under this pre-Hurst advisory jury recommendation scheme. Now, the Florida Supreme Court has said that these pre-Hurst decisions, if it was a unanimous jury recommendation of death, then the court can just treat that as a jury's determination, as a binding jury determination on the sentence, and there's no need to redo these sentencings. They can just keep those in place, keep those death sentences in place. Now, the claim here is that this actually violates the Eighth Amendment, the prohibition on cruel and unusual punishment, when a death sentence by a jury when a jury is assured that its decision is non-binding and advisory only, then treating that as a binding decision is unconstitutional, because what you've done by doing that is reduce the moral stakes in the decision and create a greater risk of arbitrary application when the jurors don't feel that they need to take their role in the sentencing scheme as seriously because someone else is there as a backstop. There's a judge there who's going to really make the final call, so a juror doesn't have to have the full moral weight of the decision that they're making. That's the argument here. But as I said, the court has not taken up one of these cases from Florida, challenging Florida's basically conversion of the unanimous advisory recommendation by the jury into a binding jury death sentence. The court hasn't taken any of these up, and so Justice Sotomayor in this dissent from the denial is basically criticizes the court for repeatedly refusing to take cases on this issue, and is very harshly critical of the Florida Supreme Court for as she sees it, not taking seriously the Eighth Amendment issue that she has been repeatedly raising and pointing out. One interesting thing about this is that her previous dissents from denial in Truhill and Middleton, in those she was joined by two other justices, Justice Ginsburg and Justice Breyer. Justice Breyer had a slightly different position because he hadn't joined the Hurst decision that Sotomayor wrote. He did not join her opinion in that particular case, so he's slightly different. But Ginsburg and Breyer basically both joined Sotomayor in these dissents from denying those two previous cases. But in this one, the one issued this week, she's on her own, and no one joined her here. It seems very unlikely that they've either of them has changed their minds on this issue. It's only been a month since the Middleton decision. So it's interesting just to speculate on why they didn't show up here. It's possible that they disagree with the tone of her criticism of the Florida Supreme Court, or maybe they just think that they've made their position clear. They've already stated their case, dissented on the record, and now it's time to just let it go and move on. Because on these decisions to grant or deny cases, it's not the dissents are not necessarily recorded in every case. A justice can choose to register that they've dissented from a decision, but often they don't. And just because a case is denied by the court doesn't mean there was no justice that was interested in taking it up. So maybe they've just decided we've said our piece and it's time to move on. And it's just kind of a reminder that on these unsigned orders, things like a denial of certiorari, others are the many orders that the court routinely issues without any indication of who's voting on either side. The lack of a noted dissent doesn't necessarily mean that a particular justice agreed with the result. That's about all for that that particular opinion. So moving on from there, the other another opinion that came out with the orders on Monday, there was a per curiam opinion in a case called Kisela v. Hughes. Now, this is a summary decision. Now, what that means is the most of the court's cases, the ones that we spend the most time discussing and talking about and that get all the attention, that's what's often referred to as the court's merits docket. And those cases, when the court grants one of those cases, there's a full schedule, a full briefing schedule where the parties file new legal briefs, and then there's oral argument before the court, and then the court will come out with an opinion. But occasionally, the court instead issues a summary decision. And what happens there is when the court formally grants the case, it immediately, at the same time, issues an opinion deciding the case. So the same day that the exact same time that the court announces that it's granting the case, it also disposes of the case by issuing an opinion right then and there. And in those cases, the normal practice is that rather than a signed opinion written by a particular justice and joined explicitly by other justices, the court issues instead an unsigned opinion, which is referred to as a per curiam opinion, which just means it's by the court. And these are very often unanimous, or at least have no noted dissents, but sometimes there are signed dissents on these per curiam summary opinions. And in this case, there was a dissent by Justice Sotomayor joined by Justice Ginsburg. Now, the other thing is, normally when the court selects cases that it grants for its merits docket, it's typically just granting cases to decide an unsettled issue of law, either some issue that's been dividing the lower courts or some new and very important issue that it feels that it needs to resolve. But it's normally major unsettled issues of law. Normally, and the court is very open about this, they don't take cases just because the lower court got it wrong. They say they don't consider themselves a court of error correction, which many lower appeals court, many state appeals courts and the lower federal courts are courts of error correction. If a mistake is made in the lower court, you can appeal that up as of right and have a higher court usually take another look at it and see if the lower court got something wrong. The Supreme Court says that's not really their job. Their job is to provide uniformity of federal law and to kind of decide these unsettled issues, not just to police the lower courts. And because of this focus, usually the court, because it's looking for these legal issues, it prefers cases with cleaner, less complicated facts. It doesn't like to wade into very fact-intensive applications of settled legal rules. That's not the type of thing that it likes for its merits docket. But these summary decisions are a major exception to that general practice. The court, in a typical year, may decide a half dozen to a dozen of these or so, something in that ballpark. Generally vacating or reversing a lower court decision. But in these cases, it's different. The court does wade into these very fact-intensive issues and is rarely really creating new settled rules of law. Instead, it's really more closely policing the lower court's application of legal standards that the court has previously laid out. And these summary reversals, they tend to be heavily concentrated in certain key areas where apparently the justices, at least some of the justices, believe that the lower courts are just not faithfully applying the Supreme Court's precedents. And one of those areas is something called qualified immunity. And that's what's going on here in this case. So this Kisela v. Hughes case, it's a qualified immunity case. And what this is about is qualified immunity is a protection for government officials who are being sued for money damages for violation of constitutional rights. And what qualified immunity does is when you sue a government official, for a constitutional claim, you not only have to show that there's a constitutional right that was violated, but you have to show that the right was this was clearly established. It has to be clearly established that whatever this government official did violated a constitutional right. And the court has phrased this in pretty demanding terms. They've said, for example, that existing precedent must have placed the constitutional question beyond debate. And this is a quote. The court has said that, quote, immunity protects all but the plainly incompetent or those who knowingly violate the law. So basically, it's a high burden that has to be met. It requires a plaintiff who wants to succeed in one of these claims against a government official to really be able to point to precedents that show that that it should have been obvious. Any reasonable government official in that position, in light of the existing case law, should have known that what they were doing was unconstitutional. And the court requires generally a pretty high level of specificity from previous precedents. It's not enough to say that certain type of conduct in a very general and vague way is unconstitutional, but there needs to be facts or very specific situations that are very close to the existing case. Now, here's the basic facts in this particular case, Kisela v. Hughes. So this is a case out of Tucson, Arizona, and there was a 911 call about a woman holding a large kitchen knife and acting erratically and apparently hacking at a tree in the yard of a house with this knife. The police, when they came into the neighborhood, the 911 caller, flagged the police down and directed them to the house where this had been happening. Now, the police saw Amy Hughes emerge from the house holding a kitchen knife at her side. Another woman named Sharon Chadwick was standing near a car in the driveway. Hughes, the one who was carrying the knife, approached Chadwick and stopped about 6 feet away from her. The police officers, who were separated from the two women by a chain link fence, they drew their guns, yelled for Hughes to drop the knife. Hughes didn't acknowledge the presence of the police, and several of the officers testified later that it seemed like she didn't even know they were there, wasn't even acknowledging their existence, and she didn't drop the knife. One of the officers, Officer Andrew Kisela, fired 4 shots, striking Hughes 4 times. The police then restrained Hughes, called the paramedics. Her injuries weren't life-threatening, and she survived. But she later sued Kisela, the police officer, for using excessive force in violation of the Fourth Amendment. Kisela argued that it was not excessive force given the circumstances, and in any event, that he had qualified immunity. It wasn't clearly a violation of constitutional rights under existing law. Now, this went up to the Ninth Circuit Court of Appeals. The Ninth Circuit found that it was a constitutional violation. This was excessive force, and also that there was no qualified immunity, that this was clearly established as a constitutional violation. And from there, a petition went up to the Supreme Court. Now, the majority here, this is the per curiam opinion, finds that there is qualified immunity. Now, the court doesn't talk about the underlying Fourth Amendment excessive force claim. The court just says, assuming for the sake of argument that this was a constitutional violation, but doesn't actually decide that one way or the other. But the court says even if it is, it wasn't clearly established, so there would be qualified immunity. Now, here's the court's description of the facts that kind of lead to this decision. Here's just some of the key facts. It says, Kisela was separated from Hughes and Chadwick by a chain link fence. Hughes had moved to within a few feet of Chadwick, and she failed to acknowledge at least 2 commands to drop the knife. Those commands were loud enough that Chadwick, who was standing next to Hughes, heard them. This is far from an obvious case in which any competent officer would have known that shooting Hughes to protect Chadwick would violate the Fourth Amendment. So that's kind of just their basic statement of some of the key facts and the conclusion that leads the court to. The court goes on to criticize the Ninth Circuit, basically saying that the Ninth Circuit was relying on cases as kind of showing a clearly established right that weren't really closely analogous, that didn't have facts that were similar enough. And also the saying that the Ninth Circuit was too quick to to kind of dispose of or distinguish away a case that was actually the most similar to this, a case called Blandford, where the Ninth Circuit had previously found qualified immunity, which the court majority thought was sufficiently similar to the facts in this case that someone aware of that case would think that they were that it was a reasonable action. Now, Justice Sotomayor dissents, and she has her opinion has a very different presentation of what she sees as the relevant facts. Here's just briefly. Here is Justice Sotomayor's kind of description of what she sees as the facts. She writes, Hughes stood stationary about 6 feet away from Chadwick, appeared composed and content, and held a kitchen knife down at her side with the blade facing away from Chadwick. Hughes was nowhere near the officers, had committed no illegal act, was suspected of no crime, and did not raise the knife in the direction of Chadwick or anyone else. Faced with these facts, the 2 other responding officers held their fire, and one testified that he wanted to continue trying verbal commands and see if that would work. But not Kisela. He thought it necessary to use deadly force, and so, without giving a warning that he would open fire, he shot Hughes 4 times, leaving her seriously injured. And she criticizes the majority specifically for not viewing the facts in the light most favorable to Hughes, or drawing inferences in her favor, and that's something related to just the procedural. The point at which this is being decided. This was decided by the lower court on summary judgment, which is before there's been a trial or before any of the facts have specifically been established. So in order to throw the case out, a court is supposed to construe everything in favor of the party that's asking to keep the case alive. And Sotomayor criticizes the justices for not viewing it appropriately in that light. And she argues that not only is there a clear constitutional violation, but there's no qualified immunity. And she runs through a number of the same cases that the majority referred to, but reads them very differently. But ultimately, the key dispute here between the majority and Justice Sotomayor's dissent is whether, under the circumstances, it was reasonable to believe that Hughes posed a threat of harm to Chadwick. And the majority and the dissent are basically reading these previous cases kind of to shed kind of a different light on that key question there. Sotomayor kind of concludes that taking the facts in the light most favorable to Hughes, it is beyond debate that Kisela's use of deadly force was objectively unreasonable. The qualified immunity dispute here between the majority and dissent is very fact bound. It kind of is really digging into these specific cases and how they're similar or different to what happened here. But possibly more interesting is after her discussion of the case specifically, Sotomayor goes on to challenge the appropriateness of using a summary reversal in this particular case. And here's some language from her opinion. She says, "A summary reversal is a rare disposition, usually reserved by this court for situations in which the law is settled and stable, the facts are not in dispute, and the decision below is clearly in error. This is not such a case. The relevant facts are hotly disputed, and the qualified immunity question here is, at the very best, a close call. Rather than letting this case go to a jury, the court decides to intervene prematurely, purporting to correct an error that is not at all clear." And she criticizes the majority's one-sided approach to qualified immunity summary reversals, basically saying that when a lower court rules against the police on qualified immunity, says there's no immunity in a particular case, the Supreme Court is very eager to reverse those cases, often summarily reverse those cases. But when a lower court has granted qualified immunity, the court is not interested in taking those cases. So she says it's just this one-sided approach, and that's an issue that a number of commenters, court watchers have commented on, that the court isn't really transparent about why it grants these summary cases, these summary opinions. It's much clearer often why the court chooses to take particular cases for its merits argument for full briefing, but not as clear how it picks and chooses which case it feels are fit for summary disposition. So that brings us now to our last opinion of tonight's live stream, and this is the one opinion that the court issued in an argued case this week. On Monday, the court issued one opinion in an argued case, which brings the total up to 18 so far for the term, of 63 total. which will likely be 62 after the Microsoft case, assuming the Microsoft case is dismissed. That means there's still 44 cases, 44 opinions that are due from the court by the end of June. Next week, the court won't be issuing any opinions because it's just in its break between the March and April sitting. There's no opinion date next week. So after that, there's only 11 weeks left of the term. So that means the court has to issue an average of 4 opinions a week to finish everything in time. That's likely to be heavily backloaded toward mid to late June. That's typical, but it's just a lot of opinions. So we should expect to really start seeing more of these coming down. But we'll see. The court has been very consistent about getting its opinions out by the end of June. They don't like to be delayed before their summer recess. So the expectation is that even though there's a lot of cases to get done, the court will churn all of these opinions out, and we will see 44 more opinions before June is out. But we'll see. So this opinion, the opinion in a argued case, this was a case called Encino Motorcars v. Navarro. And this case was a closely divided 5-4 decision, and it was along the stereotypical left-right lines with Justice Thomas writing for the conservative majority and Justice Ginsburg writing for the 4 dissenters, which is the so-called liberal wing of the court. And what this case is about the Fair Labor Standards Act. That's a 1938 statute that sets federal minimum wage and overtime requirements for employees that are covered by this act. Now, the act includes a number of exemptions, so types of employees that are exempted, either exempted from both minimum wage and overtime, or as is at issue in this case, exempted just from the overtime requirements. The list of exemptions is really something to see. I encourage anyone who's interested to look this up. If you want to find it, Google 29 USC 213. If you just Google that, it'll come right up, and you can see the exemptions from the Fair Labor Standards Act. There's really a surprising mix of job categories. Now, some of these exemptions you can kind of see why, based on the nature of the work or the typical methods of compensation, why these might have been included. But others really look like maybe they're just a special interest carve out, just some industry that perhaps some influential congressman or senator wanted to carve out of these overtime requirements. Here's just a few examples of the types of things that are included in this. For example, any employee engaged in the processing of maple sap into sugar or syrup, they're exempt from the overtime requirements. Any driver employed by an employer engaged in the business of operating taxi cabs, or any employee employed by an establishment which is a motion picture theater. Perhaps surprising, but employees of motion picture theaters are exempt from the overtime requirements under federal law. There may be differences in state law, but in any case. So the key issue here is one of these exemptions, and this one is the language at issue here reads, this is for employees of car dealerships. It's any salesman, partsman, or mechanic primarily engaged in selling or servicing automobiles, trucks, or farm implements. Now, I'm going to break this down here. It refers to 3 job categories: salesman, partsman, mechanic. In case you're not familiar with the term, I wasn't familiar with the term before seeing some of these cases, but partsman is the person who's responsible basically for managing the service department's inventory of parts, working with the mechanics to obtain the parts that are needed for particular repairs and things of that nature. So you have those 3 job titles, job types: salesman, partsman, mechanic, and 2 job duties that are listed: selling automobiles and servicing automobiles. So the question here is, what about service advisors? So service advisors is the employee at a car dealership who consults with the customers about their servicing needs and sells them servicing solutions. So the person at the desk who you actually talk to in the service department if you want to get work done on your car, and tells you about pricing and what can be done, things like that. That's the service advisor. Are they covered by this? The argument is they're salespeople. So one of the 3 categories, salesman, partsman, mechanic, they're salespeople, but they're not involved in selling automobiles. They instead sell the services that are provided at the dealership. so the argument is they're involved in the servicing of automobiles. So they're a salesman involved in the servicing of automobiles. Now, there are two competing readings at issue of this phrase. It said again, any salesman, partsman, or mechanic primarily engaged in selling or servicing automobiles. Now, you could read this as any of these following three, salesmen, partsmen, or mechanics, engaged in any of these two, selling or servicing of automobiles. That's what's being referred to as the distributive reading. You just say anything, any one of column A, any one of column B, anything that fits in those two qualifies here. And you can see a simple example of that is if you read something for a statute or regulation or something that referred to letters or packages shipped by train, ship, or plane. The intuitive, obvious reading would be you're talking about any letter, any package that's shipped by any of those three methods: train, ship, or plane, right? And so that's the distributive reading. But there's a different way you could read this, and this is what's referred to as the distributive reading. And the argument is that some of the different ones of those job categories apply to different actions. So you have salesmen, partsmen, mechanics, and you have selling and servicing. What it really means is salesmen engaged in selling and partsmen and mechanics engaged in servicing. That's referred to as distributive reading. And here's an example that kind of shows how that might work. If someone were to say, authors or illustrators engaged in writing or drawing, then the natural interpretation is you're talking about authors engaged in writing and illustrators engaged in drawing. And you were just, each of the actions was applied to one of the categories. So that's one of the key questions here. Now, just to give a little bit of history of this particular legal question, the question of whether service advisors are covered. When the Department of Labor initially interpreted this exemption, the Department of Labor said that it did not apply to service advisors. This was back around 1970. But after that, shortly after that, several federal courts disagreed with the Department of Labor's reading of this, said that the exemption did apply to service advisors. And then in 1978, the Department of Labor issued an opinion letter holding that service advisors were exempt under this provision. So the service advisors were included. So that was the 1978 opinion letter. Now, that remained the Department of Labor's position from 1978 to 2011, so about 33 years. And Congress did not act to clarify the statute at any point during that time. Then in 2011, the Department of Labor issued a new regulation. And in this regulation, the department said that service advisors are not covered by the exemption. They're excluded from that exemption. So after that, lawsuits were filed. This particular lawsuit was filed by current and former service advisors of a dealership called Encino Motorcars. It was a Mercedes-Benz dealership. They filed a lawsuit in 2012. And the Ninth Circuit ruled on the basis of the new Department of Labor rule that the service advisors were not exempt and therefore they should have been paid overtime. Now, this case has already been up to the Supreme Court once. The court decided in 2016, they vacated the Ninth Circuit's ruling, sent the case back down. And what the court basically said was that the Department of Labor's rule, that new 2011 rule, didn't adequately explain the change in policy. And so it shouldn't be relied on. And so they threw it back down to the Ninth Circuit. But the Supreme Court didn't decide what the correct rule was. They just said, don't rely on this Department of Labor regulation. And they sent it back down. The Ninth Circuit decided again and said once again that the service advisors are not exempt. And so it's back up at the Supreme Court. Now, the majority, the five justice majority says that service advisors do fit in this exemption. And here's quickly the reasoning. They say a service advisor first is a salesman under the ordinary meaning of the term. A salesman is someone who sells goods or services. A service advisor sells services, so they are a salesman. And they say that a service advisor is primarily engaged in servicing automobiles. So they say they fit under that category. They're not primarily engaged in selling automobiles, but they're engaged in servicing automobiles. And here's the description of what the majority says that service advisors do. It says they meet customers, listen to their concerns about their cars, suggest repair and maintenance services, sell new accessories or replacement parts, record service orders, follow up with customers as the services are performed, for instance, if new problems are discovered, and explain the repair and maintenance work when customers return for their vehicles. And so they characterize this as the servicing process, and that's what these service advisors are intimately involved in. Now, they say, yes, it's true that they're not primarily engaged in the actual physical repairs and maintenance, but they point to the partsmen. And they say the partsmen also are not primarily engaged in the physical repair and maintenance of the car, but everyone agrees that they must be included under servicing automobiles, or else the partsmen would be just completely left out of this statutory scheme. So if everyone agrees that servicing automobiles has to be broad enough to include the partsmen, then it must be broader than just hands-on repairs and maintenance, and would also include the service advisors. And then they go on to this issue of whether we read this as this disjunctive reading, where any one of the job categories can go with any one of the tasks, or the distributive reading. And the argument by the majority is basically just a normal reading of language when you're using a term like or to describe different categories is a disjunctive reading, where you're saying this or this, that it can apply to any one of the different categories unless there's language that's indicating otherwise. And they point to a few factors that they say support this. First of all, it's not a one-to-one correlation between the first part of the sentence and the second part of the sentence. And a one-to-one correspondence would lean toward the distributive reading, but when it's not, it's unlikely. Also, when the disjunctive reading would be contradictory or impossible, then the court says the distributive reading is favored, but that's not the case here. And it also says that this exemption suggests it's broad coverage through the use of any. It starts out saying any salesman, partsman, or mechanic, and that suggests that it's meaning to apply broadly. And then also they point to the end of this, where it applies to people selling or servicing automobiles, trucks, or farm implements. And so again, you have a list of items separated by an or, and everyone agrees there that those apply to all of the parts, to all of the different factors. So automobiles, trucks, or farm implements, any one of those three categories applies to any salesman, any partsman, any mechanic. So they say it would be odd to read that in a disjunctive way, but then read the selling or servicing in a distributive way, in the same sentence. But then the court also another argument that the court addresses is it refers to, there's a kind of something referred to as a canon of interpretation. This is kind of a rule of thumb that the courts repeatedly reference and use in deciding certain types of cases. The courts have said in the past that these exemptions, the Fair Labor Standards Act, FLSA, exemptions should be construed narrowly. It's part of a general principle that exemptions to broad regulatory schemes should be narrowly construed to better fulfill the broad purposes of these regulatory schemes. And the court basically flatly rejects this rule of thumb and just says, and it's relying in some part on a treatise published a few years back by the late Justice Scalia. It's this book right here. It's called Reading Law, that Justice Scalia wrote with Brian Garner, who's the editor of Black's Law Dictionary. And Justice Scalia's position in that book was just this, that the court is saying that exemptions are just as much of part of the statute as the broad remedial provisions of the statute. The FLSA, here the court says, contains dozens of exemptions, so it's not clear that the Congress necessarily wanted this to apply extremely broadly if it's carving out exemptions left and right. And the court says basically all parts of the statute should get a fair reading, basically without a thumb on the scale, not necessarily narrowly or broadly construing, but just trying to fairly read each part of it. So that's the basic shape of the majority opinion. Now, the dissent by Justice Ginsburg, and again joined by Justices Breyer, Sotomayor, and Kagan, it takes the opposite view. It says basically this statute was intended to exempt three well-defined positions: salesmen, partsmen, mechanics. They said Congress was well aware of service advisors at the time the exemption was written. That was a different job at these car dealerships, and Congress didn't include it in the statute. They just had salesmen, partsmen, mechanics. Congressmen knew who was normally considered a salesman, and that was not the service advisors. And then also argues that service advisors are not involved in this servicing, so they're not primarily engaged in servicing automobiles. And she distinguishes the partsmen, saying that partsmen actually do get their hands dirty. They're basically the mechanic's right-hand man, and so they are really, even if even if you say it has to be broad enough to include the partsman, that doesn't get you all the way to including these service advisors as actually engaged in servicing automobiles. And then she talks about the purpose of these exemptions and says that the purpose was the long, irregular hours that were often served by salesmen who were working on commission, and also mechanics, especially in rural areas, because one of the categories that was one of the motivating factors here were these repair people for farm equipment in rural areas who might have to go out and make house calls at all hours of the day or night to get equipment working again. And so these long, irregular hours were what prompted Congress to exempt these categories, and that just doesn't apply to service advisors who usually work a much more regular hours at a dealership. And she also, on this issue of this the construing exemptions narrowly, objects to the majority, what she characterizes as the majority rejecting a half a century of precedent of narrowly construing these FLSA exemptions. So that's the basic shape of the majority and the dissent in this case. And so that brings me to the end of this live stream episode. Our next episode will be, next live stream will be a week from today. So Thursday, April 12th, again at 9 p.m. Eastern time. That's our usual weekly live stream time every Thursday at 9 p.m. Eastern. But you can always check the Counting to 5 YouTube channel to find the next scheduled live stream. And for next week's live stream, the court is currently in recess between its March and April oral argument sittings. There's no conference until next Friday, April 13th. And then oral arguments start up on Monday, April 16th. So we're not expecting any more opinions or granted cases in the next week, not until at least April 16th. But that week, the week of April 16th, so not next week, but the following week, the court will hear oral argument in 6 cases. They have 2 a day from Monday through Wednesday that week. So in next week's live stream, again, that's the April 12th, Thursday, April 12th live stream, I plan to preview the 6 cases, each of the 6 cases that the court will be hearing the following week. That's the plan, at least. There's always a possibility of emergency orders or other interesting developments at the court. So we'll keep an eye on any of those. Whether you're watching on YouTube or listening to the audio podcast, I would love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page. You can tweet at countingto5 or send an email to mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or audio podcast to make sure you don't miss future episodes. And thank you for listening. This has been Counting to 5.